Let's get started with the last panel we have for today. And so if Professor Hamamoto had a difficult task of keeping you awake after lunch, my task is even more difficult because I will have to guide you through the final panel. For that, I will keep my own remarks to a minimum and let the speakers talk because I saw that some of them had quite a few slides. Nevertheless, I urge the speakers to stick to 20 minutes. Once it's about 20 minutes, I will start knocking on my microphone so you will hear that there is something wrong and you should speed up a little bit. But I think, okay, thank you. I will have some help as well. But I think that we move into the last session in a topic which I believe should gather some attention, in a sense that when I was writing my own PhD, and I always think that was still yesterday, but unfortunately this has been in 1988, so quite a long time ago. And at that time when I wrote my PhD on the Arctic, there was nobody who was really interested in the topic because it was the Cold War, nothing was moving there, and so one could raise the question why even start to look into the legal issues in that area. I don't have to tell you that today, of course, the situation totally changed and that the Arctic from the back burner has become very much to the forefront of international attention. And that's why I think we have the great honor to have three speakers, top-notch speakers once again, here for the last panel. We try to find somebody from Nordic countries, certainly. So we have somebody from Canada, somebody from Russia, and somebody from in between, which is Norway. And they all will touch upon the issue of from the general to the more detailed, and that's why we have we will follow the order of the program that we have. So I will first give the floor to Professor Viatcheslav. I'm not going to tell them or tell you what they have done. They're all very knowledgeable in Arctic matters, and of course it's sufficient for you to read their bios that you all have received. After that, we will give the floor to Professor Gavrilov. Professor Viatcheslav will talk about the general introduction. It will be on the application of the law of the sea in the Arctic, basic methodology. Then we will move into a more limited and specific issue, namely the continental shelf. And of course, Professor Gavrilov will tell us about the Russian submissions and Russian position with respect to all this, but it's more general. It also covers the other countries in the Arctic. And then finally, we'll have a national approach, and that will be the issues that Canada has with respect to Arctic matters, and they all will be touching upon, because that's the topic of this conference, of dispute settlement. Also for keeping within the time limits. Thanks so much. May I now give the floor to Professor Gavrilov to talk to us about the continental shelf issue in the Arctic.
Good evening, everyone. First of all, I would like to express my deep gratitude to Eric, to Helen, and some other organizers, because it is an honor to be here. Thank you very much for your hospitality. This is a very high-level conference, very actual content, and very high representatives of the people from the different areas and from the different levels, including the academics and practitioners. Speaking about my topic, I would like to say that in recent decades, the situation in the Arctic has changed dramatically, and the global warming has created expectations for economic expansion in the region. The prospect of exploiting Arctic resources has encouraged a discussion on the oncoming struggle between states for gaining access thereto, including the issue of determination and delimitation of the continental shelf of the Arctic Ocean. In this case, it is especially important not to allow political or military confrontation, but to rely on the rules of international law. This is a recent opinion, given that Arctic Ocean coastal states have so far felt it in their best interest to live up to their law of the sea obligations. The coastal states benefit from following the rules of this ensure that continental shelf extended far out into the Arctic Ocean basin. As you know, the current legal definition of the continental shelf is given in the Article 76 of the Law of the Sea Convention and represent a complicated legal construction. It has been defined there as a natural prolongation of a land territory to the outer edge of the continental margin or to a distance of 200 nautical miles from the baseline. The Convention also has linked the legitimacy of states' actions in delimiting their shelves to the necessity of receiving recommendations from the Commission on the Limit of the Continental Shelf, CLCS, which is final and binding for all. At the same time, in Article 83.1, Law of the Sea Convention excluded from the scope of its control cases of delimitation of the continental shelf between states with opposite or adjacent coasts, and entitled them to decide them for themselves by concluding agreements in order to achieve an equitable solution. All of this has created a new legal and institutional reality in the Arctic Ocean seabed delimitation, which encourages states to cooperate each other and requires that the outer limits of the continental shelf beyond 200 nautical miles are approved by the CLCS. As of today, the delimitation lines of shelves of adjacent Arctic states have been completely legally established only with respect to the northern part of the Atlantic Ocean and the Barents Sea. In the agreement between Denmark and Canada of 1973 and Norway and Denmark on 2006, as well as in two Russo-Norwegian agreements of 2007 and 2010. The delineation in the eastern Arctic Ocean still has not received proper legal registration. It concerns, first of all, the border of the USA and the Canada in the Beaufort Sea. Disagreements between the countries originated from the different interpretation of Article 3 of the 1825 Convention between the Great Britain and the Russian Empire concerning their positions in the northwest coast of America. Canada claimed that the boundary should be drawn along the meridian line of the 141st degree of west longitude and should apply for not only the land but also the maritime delimitation. The USA argued that the 1825 Convention applied to the land domain only and that the boundary needed to be established in the Beaufort Sea along the equidistant line. However, with respect to the delimitation of the Arctic shelf beyond 200 nautical miles, neither party has expressed its official position. The reason is that in higher latitudes, the equidistant lines between their coasts significantly turn to the west and considerably reduces the area to which the United States of America could possibly lay claim. Such a line becomes as unbeneficial for the USA as it is attractive for it inside 200 nautical miles. As to Canada, the situation is quite the opposite. Despite the existence of the Soviet-American agreement on the maritime boundary of 1990, the process of relative spaces delimitation in the Arctic Ocean also cannot be considered finished, as well as this agreement is being applied on a temporary basis only. According to Article 2 thereof, the Russo-American boundary runs to the north along the 168 degrees 58 minutes west meridian through the Bering Strait and the Chukchi Sea into the Arctic Ocean as far as permitted under international law. It seems to be quite an interesting legal wording because it allows dealing with the location of the terminal point in the Arctic Ocean in many ways, depending on the stage of the development of the international law, its content, and results of the agreements between the engaged state. Despite the presence of these agreements, the final delimitation of the Arctic Ocean shelf may be legally determined only after the establishment of its outer limits. The CLCS has a very important position in this process, both in terms of the stimulating effect that it may have on the achievement by the Arctic states the relevant agreements, by mere fact of its existence, and in terms of the role that the Commission plays in the uniform application of the criteria provided by Article 76 of the Convention. Russia was the first state to make submission to the CLCS, and I think that it was our great mistake, in 2001. After having undertaken a wide range of additional studies, Russia in August 2015 made a partial revised submission in respect of this continental shelf and the Arctic Ocean. According thereto, the area of continental shelf beyond 200 nautical miles covers almost 1,200,000 square kilometers. That is approximately 100,000 square kilometers more than in Russia's 2001 submission. The revised submission also provided information on the achievement by Russia of certain agreements with Denmark and Canada, which stipulate inter alia that parties do not object to the Commission considering the submissions of each other, and the recommendations of the CLCS shall be without prejudice neither to consideration of the other states' submissions nor to the process of the delimitation of the continental shelf with other states. It is obvious that this understanding provides the CLCS with legal reasons to issue recommendations of the establishment by Russia, Denmark, or Canada of the outer limits of the continental shelf in the Central Arctic Ocean, even with unsettled disagreements and disputes present. It seems to be especially important in the light of the submission made by Denmark in December 2014. 2014, which significantly overlaps the area included in the Russian submission, namely in the polar region and on the major part of the Lomonosov Ridge. In the submission, Denmark clearly stated that its position contradicts to the positions of the Norway, Canada, and the United States of America. However, these countries do not object to the CLCS considering that submission as well. At first sight, it may seem that the fact that Russia and Denmark made submissions that clearly contradict each other and that other Arctic states consented to their consideration by the Commission makes no sense. However, it turns out that the Arctic states intentionally make such submissions stipulating the rights of the Commission to consider them even where there are existing potential territorial disputes. According to my point of view, such an approach allows the Arctic states to objectively estimate their chances of success, depending on the results of the Commission's assessment of the provided information, and eventually to establish more reasoned position for the future negotiations with their neighbors. It's more than likely that for that very purpose, Russia and Denmark included special provisions into their submissions, stipulating that they reserve the right to introduce amendments in addition to the CLCS, and that after the Commission issues its recommendation, the final decision of the Arctic Ocean shelf delimitation shall be provided in accordance with Article 83 of the Convention. In this regard, the official Canada's submission to the CLCS will also be of considerable importance. As soon as scope of Canada's claims to the Arctic shelf is known, the limits of intersecting zones in the Arctic Ocean will take shape, forming the basis for negotiations. However, Canada only submitted the required preliminary information in 2013, having revealed the possible inclusion into its continental shelf the certain areas of the Canada and Amundsen Basin, Lomonosov and Alpha Ridges. Some Canadian scientists estimate that the country's extended continental shelf in the Arctic will be 750,000 square kilometers. Besides, Canada stated that it would make partial submission to the CLCS concerning the Arctic Ocean at an appropriate date. However, it still has not happened, and I think there are at least two reasons for this. This is my private opinion. First of all, taking into account the submission of Denmark, which lays claim to the part of the shelf north of the Canadian Ellesmere Island, it would have been more rational to wait for the decision of the Commission on the validity of that position rather than once again stress the existing disagreements between Canada and Denmark by making its own submission to the Commission. And secondly, under conditions of a long-term scientific research of the continental shelf being concluded by Canada together with the United States of America in the Beaufort Sea, and existing disagreements between them on the principles of delimitation, Canada's unilateral submission may decrease trust and increase tension between these two states. Moreover, the lack of clarity concerning the drawing of the western limit of Canadian Arctic shelf makes possible its delimitation from the shelf of the United States beyond 200 nautical miles along the medial line rather than 141st meridian west. In this case, not only Canada and the United States will have a common continental shelf boundary, but Russia and Canada as well. This will create an absolutely different legal reality since Russia still has no agreement with Canada similar to that concluded with the USA in 1990. The foregoing allows coming to the following conclusions. The process of legal delimitation of the Arctic continental shelf is only beginning to develop. And despite the presence of some agreements concluded by adjacent Arctic states, the problem is still far from being finally resolved because such agreements do not regulate delimitation in the polar area. It is because the prospects of territorial delimitation in the Central Arctic Ocean looks more complicated, as it will require the delimitation of the shelf between not only adjacent but the opposite states. It is further worsened by the lack of sufficient quantity of universally recognized scientific data that could shed some light upon the origin and nature of submarine ridges and rises in the Arctic Ocean and establish their compliance with the requirements of the Article 76 of the Law of the Sea Convention. It means, I think, that attempts of states to unilaterally resolve the problem of delimitation of the Arctic Ocean seabed based on their own vision will still be the keynote of that process in the near future. At the same time, it looks very likely that making submission to the CLCS or agreeing with the consideration by the Commission of other submissions, the Arctic states are not going to treat future recommendation as final and binding. They refer to Article 83 of the Law of the Sea Convention and look at the Commission like an expert body capable of confirming or discouraging their vision of the shelf delimitation. Moreover, one should not forget that pursuant to Article 8 of Appendix 2 of the Law of the Sea Convention, in the case of disagreement by the coastal states with the recommendation of the Commission, the coastal states shall make a revised or new submission to the Commission. This process potentially may last forever, since the establishment of the outer limits of the continental shelf is the sovereign right of a state, and the Commission is only entitled to provide recommendation thereon. One should not forget also that the United States of America is not a party of the Law of the Sea Convention, thus not being bound by the provisions of Article 76 thereof, and not being obligated to make a submission to the Commission in order to receive recommendation on what the outer limits of its continental shelf should be. That is why its relation with the other Arctic states on the issue should be guided by the provisions of the 1958 Geneva Convention of the Continental Shelf, or of Article 83, or other articles of the Law of the Sea Convention, insofar as they constitute rules of the customary international law, confirmed in particular by decisions of international courts and tribunals. All this means that one Arctic state should not treat unilateral submission or statements of other Arctic states as reasons for pessimism and confrontation. They are intended solely, at least I'd like to think so,
to outline their starting positions and create a subject for the subsequent international negotiations, format of which may be vary from the parallel bilateral consultation to a full-scale international conference of Arctic states. It means that the problem of delimitation in the Arctic Ocean continental shelf can finally be resolved only by means of these negotiations, taking into account the interest of all the involved parties. Thank you.
Thank you so